Hey everyone, welcome back to Glassratner's Business Interruption webinar series. So there's been a lot of litigation activity of late relating to COVID litigation. And it's been a while, but we were talking in the past about multi-district litigation and class action. There's been a few interesting rulings that came out this week. The University of Pennsylvania has a COVID coverage litigation tracker, which notes that there have been 884 cases that have been filed in various districts across the United States. So this multi-district litigation and class action are a few of the efforts to kind of consolidate some of those actions to make it more efficient. You know, they tend to center on a few common threads. One is whether the coverage is actually triggered by COVID and contraction of the of COVID on property. And then second, whether certain sublimits or exclusions that are prevalent in a lot of policies that apply. So again, multi-district litigation and class action are two of the efforts to be able to try and consolidate some of those cases and make it more efficient to work its way through the court, so you don't have varying decisions from one district to the next. In particular, the United States Judicial Panel on Multi-District Litigation issued a ruling in the COVID-19 business interruption protection insurance litigation. And essentially, they did not allow consolidation in the MDL format. There's some other language in here that I thought was interesting that centered on a couple common questions. One is, do the various government closure orders trigger coverage under the policies, like we were talking about before? Second, and kind of in that same vein, is what constitutes physical loss or damage to the property? And this is something that we're seeing throughout many of the cases about whether COVID can be construed as physical loss or damage to property that would ultimately trigger some of the coverages. And then third, do any exclusions, particularly those related to viruses, apply? In the order, the panel suggests that the questions, though, share only superficial commonality, and there's no common defendant. They're also, they suggest that the cases involve different insurance policies with different coverages, conditions, exclusions, and policy language purchased by different businesses in different industries located in different states, and then goes on to state that these differences will overwhelm any common factual questions. Interestingly, though, they seem to leave open the door for insurer-specific MDLs. And in the order, it suggests that it's more likely to involve insurance policies utilizing the same language, endorsements, and exclusions, so obviously some more commonalities. So further to that front, we see an order come out of Missouri, the federal courts, specifically to class action against Cincinnati Insurance. In it, the federal courts denied to dismiss a case against Cincinnati Insurance on COVID-19 coverage suit involving several restaurants and salons. These involved mainly some insurance policies, some all-risk insurance policies that did not specifically have virus exclusions. So again, you see some of that common thread where the courts are trying to drill down on that issue of commonality. In the ruling, the court noted that, quote, the coverage COVID-19 allegedly attached to and deprived plaintiffs of the property, making it unsafe and unusable, resulting in direct physical loss to the premises and property. So they're starting to try and break and rule on some of these issues that we're talking about, you know, whether the physical loss or damage coverage triggers the coverage. And in this case, they didn't necessarily have the specific virus exclusion issue, that second issue that we were talking about before. But we're starting to see, you know, there's been some rulings that came out of one in Michigan, you know, and various places across the U.S., you know, so some of the suits that they're starting to be ruled on, and some are going forward, some are not. So obviously that's there's a lot of activity with almost 900 cases being filed across the U.S. You know, there's a lot to keep track of. We'll do our best to try and report back as time allows. And so, you know, those were a couple of the more interesting cases that we saw of late. There's been cases in Michigan and a few others that have been decided. And so some states are friendly to certain arguments, friendlier than others. So, we'll keep tabs on it and try and keep everyone in the loop as we see it. But I just want to thank everyone again. Stay safe. And until next week, thanks for joining us for another episode of Glass Ratner's Business Interruption webinar series. Bye now.